What is it like? What are some of the main differences in taking appeals up to the Appellate Division? Most trial attorneys know a little something about taking appeals up to the Court of Appeal. But I'll just share recently, I haven't done a lot of practice in the limited civil division, but my first foray into it was realizing that I was the respondent, and I realized that the appellant had assumed the normal timeline applied to file a notice of appeal. They had assumed they had 60 days. They only had 30 days. So we got that appeal dismissed.
Wow.
Wow. That's a good one. So someone gave notice of entry of judgment, which is rare on the limited civil.
Right. Okay. And there was even a motion for new trial. Those deadlines, those extensions are all cut in half as well. So,
oh wow.
So that was one tip I'll always keep in mind is know all of the rules, the timelines to file the notice of appeal, and remember that they're all cut in half if you're in limited civil.
I'll tell you another thing. Not only that, if you're practicing in Los Angeles Appellate Division, I don't know about the others. I've never filed in any of the others. You better know the rules inside and out. It is maddening. Unlike the Court of Appeal, where you can call court and go, oh, I see what you did there. Oh, I'll fix it. Oh, I'll help you. Oh, I'll give you another day. They'll just, boom, strike it. And I recently had the experience where they have a new rule of they're now accepting appendices. Thank God. Used to only be clerk's transcript.
Oh, wow.
I didn't know that.
So I filed on time, and they sent it back. They sent back my appellant's opening brief, and my appendix said I hadn't complied with the rule on appendices. I looked at my appendix. I looked at the rule. I could not see anything wrong. They didn't specify what it was. So I went down there. Now I'm 2 days before my deadline. And I mean my extended deadline. So I got to make sure this thing gets on file. And I'm there with this nice clerk lady, and she goes over it with me. And she goes, I see what you mean. I don't see what part of the rule you've broken either. Will you accept my appellant's opening brief and appendix for filing? Yes. Okay.
Oh, all right.
Well, she accepted it. But the story doesn't end there. 1 week later, I get it back in the mail with a strike through saying, now I haven't complied with the rule governing clerk's transcripts. I'm like, no. So I got on the phone and had a long talk with the supervisor where she and I had a spirited discourse about the meaning of the rules of request for judicial notice, appendices, and clerk's transcripts. And she says, well, no, I'm sorry. I don't think so. And I said, so what should I do? She goes, you're going to have to do it the way I'm telling you, and also file a request for relief from default. I said, I'm in default. Well, yes, you are. Well, I haven't received an order of default. Oh, well, you better file a request for relief from default anyway. She had put me in default.
Wow.
So that is the kind of thing that happens in the Los Angeles Appellate Division. I really wish they would do something about the, well, I don't know how to say it. I mean, they have a certain way they do it, and it's just crazy maddening because you get stuff from the other side and it doesn't comply with the rules at all.
You're running afoul of the local rules.
Yeah, it's the local rules for sure. And then also there's no e-filing. It's all got to be on paper. You've got to send messengers.
Oh my God.
It's crazy.
Wow. You've convinced me never, ever to handle one of these appeals.